Good evening, everybody. I'm going to read some of the procedures of the 40As, which is mostly everybody here, and then I have an explanation for our first one on the agenda, 40B. So the City of Peabody Zoning Board of Appeals meets tonight in accordance with Massachusetts General Laws, Chapter 40A, and other applicable laws. Tonight's hearing will be conducted in the following manner. The Secretary will read the legal notice or state that such a notice has been waived. All applications this evening will be heard in the order they were received in the City Clerk's office. The petitioner, which is you, or petitioner's representative, your builder, your attorney, will present the subject application to the board. Come up to the podium, state your name and address for the record. The chair may limit the length of all remarks. All parties in interest will be given an opportunity to speak in favor or in opposition to a pending application, and the board may receive similar written communications to be placed on the public record. I'm just going to very quickly, this is a very long agenda this evening, so I'm going to explain that very quickly. I usually go in a little bit more detail. However, when it's your turn to come up, state your name and address for the record, and then you tell us what you're here for. We're here for dimensional relief, a farmer's porch, a garage. You need a variance because you don't have enough room. When you're done, the board will probably ask you a few questions, and then I will say to the audience, is there anybody in the audience to speak in favor? That necessarily, usually always means your neighbors. And they will come up and they will probably say something very nice about you, what a wonderful neighbor you are, and that's great. I then say, is there anybody in the audience that would like to speak in opposition? And once again, that would be your neighbors. And sometimes we get a lot of opposition. If that is the case this evening, please keep in mind, if there are 5 people in front of you and you want to speak in opposition, and they've already said everything that you want that there is to be said, just state your name and address for the record, and you can just say, I agree with the 5 people. I'm in opposition of building this 18-story addition. When you are speaking in opposition, we need to keep to the subject matter. So what I mean by that is we don't want to hear all the things that you, in your opinion, you don't like about your neighbor. A barking dog, a loud radio, kids that stay up all night, leaves falling in your pool. We're not concerned with that. I'll do this. That means, sorry, we're not going to listen to it. The other thing is, please do not say and shout from your seat. I say that every meeting, and every meeting somebody decides that once they sit down, they've forgotten to say something and they shout it out from their seat. Please don't do that. At the end of that opposition time, you, the petitioner, can come back up to the podium and address some of the issues, or your attorney or your builder. At that time, we might also ask a few questions, and then the decision, after we vote, will be typed and filed with the city clerk, and once that decision is filed with the city clerk, the 20-day appeal period begins. In compliance with the open meeting law, this hearing is also being recorded by our clerk. When you come up to the microphone, just turn it on, speak clearly, and let me just say there is no cell phone videotaping without notifying us first, and we haven't been notified of that this evening. We also are broadcast live on Channel 9, and believe it or not, we are live on Facebook. Meeting minutes are made public, and new applications, information, plot plans, renderings, etc. should be passed in to our clerk administrator before the deadline, not the day of the meeting. So let me just expound on that a little bit. If we have late communication on anything this evening, if you've passed it in 5 minutes ago or this morning, that's late communication, and that cannot be viewed by us this evening. So that's normal. Now we're going to go into our 40B, which is happening, which is number 1 on our agenda. I'm going to speak a little more slowly this time. I have a lot to say, and I'm sure that there are a lot of people in the audience that need to take note of this. Good evening, ladies and gentlemen. Welcome to the Peabody Zoning Board of Appeals. Before the clerk, oh, I already read all that, okay. Our first agenda item is 40 Oak Street Development, LLC, for a Chapter 40B comprehensive permit application. I'm going to provide to all concerned a brief procedural summary that forms the background to this board's management of the required process. On July 12th, 2019, 40 Oak Street Development, LLC, filed its comprehensive permit application with the city. Initially, there were legal questions between the applicant's lawyers, our city solicitor, and Mass Housing concerning the site eligibility extension. That issue does not now concern this board. That resolution then resulted in a confirmation dated July 16th, written by the ZBA administrator, that the application was indeed accepted for processing and scheduling, and all statutory compliance dates would be calculated as of July 12th, the effective date stamp of the filing. The filing was then and there a public record. On August 1, Mayor Betancourt wrote to both the board and the applicants via their lawyer, transmitting the materials the city has submitted to Mass Housing back in 2016 when the applicant was pursuing site eligibility approval. He also notified the board that he expected a large number of participants in the hearing process drawn from the concerned neighbors, elected officials, and department heads. He alerted the board of the necessity of realistic scheduling so that all parties may be afforded adequate time to present his, her, and their views. He also offered to fund a hearing officer to assist the board in this process. As chair, I sought further help from the legal department in hopes of complying with the requirements of a 40B adjudicatory hearing. Subsequently, an email was sent on August 1 to the applicant's lawyer, Ms. Kiefer, inviting a discussion about procedure and scheduling and, of equal importance, avoiding a board member participation issue since Peabody does not have the Mullen Rule. On August 2nd, I will read to you the interchange between lawyers, which was copied to the mayor, other interested elected officials, and myself. Hi, Attorney Stephanie Kiefer. Thank you for the discussion with Chair Gallucci and myself. Here is our proposed agenda for Monday. Adopt the 40B rules, discuss using a non-voting advisory officer to assist the board, issue of recusal of Mr. Osborne, opening the hearing to allow the clock to start, invite applicant to make a brief opening statement, schedule hearing dates for presentation of applicant's case, city department head testimony, issue of peer review, abutter, elected official testimony, peer review contribution, rebuttal, and deliberation. Mayor and Councilor McGinn, please let your participants know about this process. End of that conversation. Shortly after the conference call with Attorney Kiefer, the city solicitor, and myself, and the email I just read, I was notified that the applicant's lead counsel, Mr. Smolak, would be requesting a 60-day continuance and extension on both the initial hearing date and the 180-day time period within which the board is required by law to decide the matter. On August 5, Attorney Smolak did in fact submit a letter making those requests. The board did agree with the rescheduling. As a matter of clarity, the board would have been required to make its decision by February 1, 2020. Now the board has until April 1st, 2020 to render its decision on this application. I want to be perfectly clear that no one has approached us as a board with substantive arguments or provided information outside the process we are here to protect. I know I speak for the whole board, and consistent with its history and reputation, that it is committed to evaluating this application like all others with a fair and impartial mind. I must now return to the to-do list from the email I read. I would like to address those items one at a time. 40B rules. Community Development determined that a prior ZBA did adopt rules and our administrator has made copies here tonight. They are in a stack on the railing. It looks like people already found some. Under the topic of 40B rules, I can also indicate that this board has its own rules, one of which has to do with late communications. Late communications can only be accepted by a unanimous vote of the members present. As a matter of practice, I cannot recall when we as a board have accepted a late communication. Non-voting advisory officer. We have the pleasure of welcoming Mr. Larry Beals as one quite knowledgeable in 40B matters and has recently served as our litigation expert in the Washington Street, eminent domain, and land damage cases. The mayor has pledged funding for Mr. Beals' services. We soon will discuss his role. At this time, I would like to invite Mr. Beals up to the podium to give us a little information and background about himself.
Thank you, Madam Chairman. My name is Larry Beals. I work with a firm called Beals Associates, and I have essentially been working in this profession since 1974. I use that point just to underscore that I have quite a bit of experience. Some of it's good, some of it's not so good, but I certainly have a lot of experience. And having worked in this profession for such a long time, I've seen a lot of projects over the years from all different perspectives. And then in 1983, I founded Beals Associates. It's a firm that focuses on planning, civil engineering, permitting, and construction management. Recently, I have worked with the city of Peabody on an eminent domain taking. And as a consequence of that fairly lengthy process, I am familiar with the city's high standards in terms of how professional services are executed and how decisions are made. So I feel well qualified for that. On a professional basis, I have designed and successfully permitted a number of 40B projects, so I understand the applicant's side, and fortunately, the projects I've been involved in have never been appealed. I also served as the chairman of the ZBA, similar to your role, in the town that I live in, and a 40B application was made, which was a lengthy, fairly contentious process. It resulted in a positive decision, which was subsequently, unfortunately, appealed. So I have an engineering, land planning, civil engineering, permitting background. I believe my role here is to assist the board across the board on every aspect of this process. My role is not a peer reviewer. I'm not going to be looking at traffic on a detailed sense. I believe the board may have an opportunity to hire peer reviews for those responsibilities, but I will be an advisor to the board. Thank you. Thank you.
Thank you, Mr. Beals. Issue of recusal. Board Member Osborne has raised the issue since he is a member of the fraternal organization selling the project site to the applicant. The initial review reflects that he and/or his immediate family would not have any financial interest in the outcome of this matter. In the spirit of open discourse, I certainly invite the applicant's representative to add to the analysis all before we start. We have plenty of members to complete this process despite not having the Mullen Rule in place. Let me just add here that Mr. Osborne has made it clear to me that he is not going to recuse himself. However, that might be something that the applicants need to think about because he's a member. I would invite the applicant to make a brief statement at this time to start the clock. Please just describe the project in its general terms and address if you want and address the 3 issues if you want I just identified, those being 40B rules, advisory officer Mr. Beals, and Osborne's recusal question. I then would like to continue with the list about scheduling for all involved. Attorney Smolak and the Larkins, I believe. Whoever wants to begin.
Good evening, Madam Chair, other members of the board. For the record, John Smolak, the firm of Smolak and Vaughn, 21 High Street, North Andover, representing the applicant, 40 Oak Street Development, LLC. Madam Chair, we were prepared to do a full presentation, but with the understanding, given the schedule that you have ahead of you and the other items, yep. In addition to the
There you have it. As I said, somebody always wants to shout from their seat.
Madam Chair, thank you. Given the length of the schedule that the board has this evening in terms of an agenda, I want to respect that, and also understand that the board would prefer to set out some scheduling with respect to the hearing, future hearings for this proposed project, which is fine with us. If you wanted us to go forward with a limited presentation, we would, but I'm not sure it's essential, but it's really up to the chair whether she wants to take that time to do so. We have representatives with us in terms of our project architect and the project applicant's principal, but nevertheless, okay, fair enough. As to the issue of a potential conflict or ethical issue, that's the first that it was raised to me this evening. I wasn't aware of that. I haven't had a chance to speak with my client about that. My sense is that we aren't speaking about substantive issues this evening, and I'd prefer to have that discussion with my client about that. If that's and come back to you at the next meeting if that's fair. Okay. And in terms of the 40B rules, I wasn't quite sure what you had suggested. Oh, yes, absolutely. We're happy to work with the board on that as well in terms of a time frame. We did request a continuance for a 60-day period at the last hearing that we're at. Frankly, I think it was a waste of time. But we're proceeding full steam ahead, full speed ahead with the proposal that we have this evening. And happy to have a discussion. We're very happy that Mr. Beals is representing the board as well, because I think that'll help matters progress in the fashion which they should. I had a set of 40B rules that, yes. Okay, thank you. But in terms of scheduling, happy to work with the board in terms of scheduling of various issues. That's how we feel that applications are most efficiently undertaken.
We're going to do that at the end to make sure that everybody here, we have some dates ready to
Great,
throw out.
great.
Okay,
Thank you.
thank you.
That's all I had at this point.
Is any of the Larkin men here? Oh. Do you want to speak on anything? Okay. That's taken care. Right. Okay. All right, returning to this list, I believe it is wise for us to set a schedule with specific tasks to be accomplished on each of the dates we select. So, everybody get out your calendars. So now, what happens is, because we have so many different aspects and parties involved that want to hear the 40B, that want to speak. Would be almost impossible to do that all this evening. So we are going to schedule all the parties involved and dates, and that's all that would be heard that evening. So tonight's meeting is a scheduling meeting, and we're going to start that right now. So we need to hear a full presentation of the applicant's case. We need to hear from the abutters, the elected officials, and the late communication by Attorney Olivieri. We would like to do that November 4th. I'll repeat it, I will repeat it, and I will hear from the board and anybody in the audience that's involved in, if that's not a good date. So November 4th, full presentation by the applicants, the abutters, the elected officials, and the late communication we received today by Attorney Olivieri. It's not a motion. No. Are we all set so far? Mr. Beals, are you good?
I don't have a choice.
So the applicants, any of the abutters that are here this evening, elected officials that are here this evening, are we all set with November 4th? Fine. Next. November 18th is just our regular zone, yes, Pete? Come to the podium, please. This is just to do with the date. Don't ask me anything else, please.
Strictly to do with the date. There's a municipal election on November 6th. It's a particularly busy time for elected officials that might be involved in that election, so that November 4th is might represent a hardship for a number of candidates in that election.
Well, you know what? We did take that into consideration, but Carla?
We left November 25th open in case there was an issue.
So what we're going to do is this. We're going to leave elected officials on November 4th, but those elected officials that couldn't make it because they were out campaigning, we left November 25th, which is what I was just going to say, for them to speak also. So
Thank
we
you.
have you covered.
Appreciate your flexibility.
Yep. Thank you very much for that. So November 18th is our regular zoning board meeting. That only we have to be concerned with that. November 25th is open for any abutters or elected officials, any updates that if we didn't get through an elected official or an abutter on November 4th, then November 25th, that's sort of an open meeting. You can come back and meet with us November 25th and say whatever you have to say. Because these meetings probably will have an hour timeline, maybe an hour and a half. You know, if we're getting to 9, 10, 11 o'clock, that's why we gave November 25th as another date. December 2nd, we're all set with November 25th here?
Yeah, I get an arbitration at 2 o'clock in Waltham, but I should be out of there in time to be here by 7.
Okay,
And we have the regular meeting on the 18th,
we do.
and we're not doing anything with this on the 18th?
No,
Okay. Is that wise?
yeah,
Okay,
that's what we were advised.
okay.
December 2nd, the department heads and peer review. December 2nd, department heads and peer review. This is, ladies and gentlemen, obviously going to take into the new year to hear everybody and to give everybody a chance to investigate and get in touch with traffic and et cetera, et cetera, et cetera. So this process is lengthy, but we're going to get through it. So we all set for December 2nd. December 16th is just our regular meeting. January 6th would be the department heads peer review. That peer review and department heads, once again, need a little bit more time, so we're giving them another date. January 6th. January 20th is our regular meeting. February 3rd, rebuttal and deliberation. This will be a big one. February 3rd, we're hoping, with the rebuttal and the deliberation, that the zoning board will have everything it needs, everything will have already been presented, all ducks will be in order, and hopefully we can make a decision and a vote on February 3rd. That's what we're looking at. So I hope you understand, everybody that's here this evening, we had to break it up and we had to schedule all parties involved because there is no way we could do this in 1 or 2 meetings. Everybody needs a chance, everybody's voice needs to be heard, all department heads, peer review, they all need time to gather their information, present accordingly, and get it straight out. So, are there any questions? Anybody need anything repeated for the dates?
Thanks, Madam Chair. Just John Smolak, attorney for the applicant. The dates seem to be fine with us. The only question is in terms of the ordering of materials, and certainly understand that you want officials and the department heads and abutters to identify issues of concern. I assume as part of that discussion, basically those folks will be giving testimony. You're not expected us to respond back and forth for those meetings. Also, in terms of the later meetings, what I found particularly helpful at some point, instead of bringing the entire project team to a hearing, that perhaps you break them down by issues. For example, stormwater could be one.
Okay, so would you mind to just stand aside for
Sure.
a minute? I'm going to ask Kurt Bellavance, our head of community development. Kurt, are you still here? Could you just speak a little bit to that peer review and the different departments, please?
Sure, thank you. Kurt Bellavance, Community Development Director for the City of Peabody. Yeah, certainly as part of the application, we would review issues such as traffic, stormwater, site design, public drinking water to the site, wastewater leaving the site, natural resource issues in regards to conservation, floodplain, those issues. So those are, I would say, the major points of the application that we'd want to review. Certainly, we'd look for peer review on some of those. For example, traffic. We don't have traffic experts on hand with the city, so we typically would hire independent traffic consultants to do that work for us, as well as water, wastewater site design. So those are probably the 4 biggest areas that we'd be taking a look at and looking to have peer review to help us and assist us with that.
Does that answer your questions?
It does partially, and the only question I have is, in other 40B hearings that I've been involved with, typically the applicant would have an understanding of who those peer review consultants would be and the nature of their discussion. We typically would have the ability to review the scope that's being proposed to make sure everyone's on the same page, to make sure it's a process that'll be as efficient as possible. And so when the board looks to retain consultants, it would be helpful to know who those consultants are, number one, to deal with the issue of the scope, but number two, to make sure there aren't any conflicts with the work that those peer review consultants may be doing with one or more of the members of our project team. I think it's always helpful to have that process undertaken initially.
So that's fine. Are you asking to work directly with Kurt and get what you just asked from Kurt?
Sure, I'd be happy to do so. Yes, and also frequently what I've found helpful to make the process more efficient, to the extent that the board feels that it would be helpful to have a subcommittee have discussions on certain technical issues that may take an extensive amount of time, that perhaps the peer review professionals for the project team, as well as for the city, could collaborate with one another, not during a hearing process, but bring that information to the hearing as a result.
Is there a question for me? Well, I mean, typically we would have, we have consultants that we work with now. For example, World Tech has been working with us in traffic. Weston and Sampson reviews our water. I'm not exactly sure who does sewer. That's through the DPS, and then also site design. So those would be the areas, and certainly we can get them a list of who they would be. We'd forward those applications to them. They would put together a scope of services and what they would review. We would certainly show that to the applicant on hand to see what we're going to be reviewing and so forth. So it's a process that we would work back and forth with to get that resolved and get the information back to the board.
That's what you're asking.
Yeah, yes, that's partially what I'm asking, and also what I'm saying is that also, to the extent it might be helpful to the board, if there are discussions between the peer review consultants for the city as well as the peer review consultants for the applicant to hash through some of the more technical issues, and then bring those back to the board at a later time. I just want to leave that option open if the board's willing to consider that.
So, you, with all the technicalities, you, Kurt, Mr. Beals,
If you feel it's necessary to involve the lawyers, I was just speaking in terms of simply having the engineers speak to the engineers.
lawyer.
Yeah, no, I understand that. No, he's a very reputable engineer, I know. What I was suggesting is that not to have a lawyer speak to as part of the process unless the board or the subcommittee feels necessary. But all I was simply saying is that perhaps to hash out the technical issues, just have the engineer talk to the engineer directly, and whatever is discussed at that point, and any communications be delivered back to the board to report. It's just a matter of, I think it makes it a little more efficient as a process, that's all.
And Mr. Beals can moderate that.
Okay.
Yeah, and typically we would have the Department of Public Services Director involved as well, since water and sewer involves their department as well.
Perfect. We all in agreement of this, then? Everybody happy? All right, so everybody that's here for 40 Oak Street, what? What did you say? November 4th is our next meeting. So you can go home and watch the game. Thank you. Make a...
Excuse me, Madam Chair.
Chairman, move to continue to, oh, I'm sorry, go ahead.
Sorry. I just wanted to ask if the board was taking a vote to continue the hearing to
Yeah, we're going to do that now.
number, okay, thank you.
Madam Chairman, move to number 4.
Second.
All in favor?
Aye.
Any opposed? All set on that. Thank
And that
you.
would be here at 7 o'clock.
Yes.
Thank you very much. Appreciate it.
Okay, here we go. We want to get over. We're now ready to do number 2. If you're having a conversation, could you please take it outside? Number 2, the application of 7 Dearborn Limited Partnership. Go ahead.
Notice is hereby given that the Board of Appeals of the City of Peabody will hold a public hearing on Monday, October 21st, 7 p.m., Wiggin Auditorium, City Hall, 24 Lowell Street, Peabody, on the application of 7 Dearborn Limited Partnership, care of Attorney John Kelty, for variance from the provision of the zoning ordinance 2019 as amended specifically Section 6.6.8 as it applies to the premises known as 7 Dearborn Road, Peabody, map 78, lot 19. The petitioner seeks a variance and requires relief from provisions of the DDD Residential Overlay District, Section 668 as follows: density of 33 units per acre where 20 units are allowed, 295 parking spaces where 315 are required, setback from residentially zoned land 68 feet where 100 feet are required, max FAR of .87 rather than .5 allowed. The property is located in a DDD zoning district. The application and plan are available to the public and can be viewed at the City Clerk's office and Board of Appeals office, City Hall in advance and prior to the public hearing.
Thank you, Mr. Sensbaugh, and members of the Board of Appeals. My name is John Kelty. I'm an attorney. I practice law at 40 Lowell Street in Peabody, Massachusetts, and this is a variance that has been previously granted. As I filed a copy of the decision, it was April 24th, 2019. We recorded the decision of the Board of Appeals at book 37519, page 523, and then we went before other boards, including Conservation Commission. We just last week finished at the Conservation Commission and now have an order of conditions. We are still working through a site plan review process, and this variance has lapsed in the meantime, and I'm asking for the exact same variances that were granted back in 2019. In April of 2019. There is no change. There's been nothing that has occurred at any other board which has caused us to seek additional or different relief from that which were already granted. It's just a matter of the variance having lapsed, and we would seek your approval this evening. Thank you very much.
Everybody all set here on the board? Anybody in the audience to speak in opposition? In favor? Hearing none, the matter is before the board.
Motion to approve?
We are giving you a, a new variance.
Yep, and you can put the same conditions that were on the other one, which require us to have approvals from Community Development Authority and Community Development Department.
We will do. All in favor? Aye. Any opposed? Thank you, Jack. Number 3 is, I need somebody to accept this. It's withdrawing without prejudice.
Read this into the record.
Yeah, go ahead.
We received an email from Attorney Ethan Vonsalidis regarding the third item on the agenda regarding 3 Pine Street. Hi, Carla. Please treat this email as my request to withdraw without prejudice the above reference variance application. Thank you, Ethan Vonsalidis. So I will move to allow that withdrawal.
All in favor?
Aye.
Any opposed? Great. Number
Notice hereby given that the Board of Appeals of the City of Peabody will hold a public hearing on Monday, October 21st, 7 p.m., Wiggin Auditorium, City Hall, 24 Lowell Street, Peabody, on the application of Melissa Reed for a variance from the provision of the zoning ordinance 2019 as amended Section 7.2 as it applies to the premises known as 19 Rockdale Ave, Peabody, map 116, lot 148. Petitioner seeks variance and requires relief to the front yard setback where 20 feet are required and 12 feet are proposed. The right yard setback where 15 feet are required, 7.3 feet are proposed. This property is located in R1A zoning district. The application and plan are available to the public and can be viewed at the City Clerk's office and Board of Appeals office, City Hall, in advance and prior to the public hearing.
Hi, I'm Melissa Reed, 19 Rockdale Ave, looking to apply for a variance for a farmer's porch for our home.
look like there's any place you can put it without needing a variance, so.
Anybody in the audience to speak in favor? In opposition? Hearing none, the matter is before the board.
Motion to close the public hearing. Motion to approve.
Favor? Aye. Any opposed? All set.
Thank you.
Notice is hereby given that the Board of Appeals of the City of Peabody will hold a public hearing on Monday, October 21st, 2019, 7 p.m. Wiggin Auditorium, City Hall, 24 Lowell Street, Peabody, on the application of Cy Tenney Residence, LLC, care of Attorney John Kelty, for a variance from the provision of the zoning ordinance 2019 as amended sections 6.16 Residential Overlay District as it applies to the premises known as 190R, Newbury Street, Peabody, map 35, lot 38A. Petitioner seeks a variance to construct 60 residential units and requires relief to the front yard setback where 225 feet are required and 108 feet are proposed. Rear yard setback where 90 feet are required and 33 feet are proposed. Parking lot location of planting area. The property is located in a BR1 zoning district. This application and plan are available to the public and can be viewed at the City Clerk's office and Board of Appeals office, City Hall, in advance and prior to the public hearing.
Okay, I have a woman in the audience that says she can't hear. What we're doing here now, what the secretary does is he reads the legal notice. So that gives the address and what exactly they're looking for, and now the attorney will expand on that. And it's all in the agenda. We had quite a few agendas, and that's all listed, but there are no more agendas left this evening, I'm sorry. Speak from our seat, thank you very much. Mrs. McGrath, what did you say? Not accepted.
Thank you, members of the Zoning Board of Appeals. My name is John Kelty. I'm an attorney. I have offices at 40 Lowell Street in Peabody, Massachusetts. And I appear on behalf of Cy Tenney Residence, LLC, who is the applicant for relief from the zoning board of the zoning ordinance of the City of Peabody as it applies to the residential overlay district, which was recently adopted by the City of Peabody City Council and the Peabody Planning Board. In my application, I've requested the relief as set forth in both the application and set forth in the schedule for this evening, and also was read into the record by Mr. Senzabaugh, the clerk of the board. The current property owner is J.G. Backland Realty Trust. My client, Cy Tenney Residents, have entered into an agreement to purchase that property, finalize purchase of the property, and we have been before the Conservation Commission for a period of, I think we were at the Conservation Commission for a year and a half, and we did finally get an order of conditions, and I have affixed the decision of the City Council, which was dated July 16, 2019, in which the City Council determined that Cy Tenney residents be given a special permit seeking to construct the 60 units residential units at 190 Rear Newbury Street, and they did this in accordance with the residential overlay district and its guidelines. In their decision, they did say that it must be that the site must be developed in accordance with the site design criteria listed in the zoning ordinance, which at that time when we were appearing was just about to be put on the books and approved by the City Council. So we went through the plan with the building commissioner, noted what deficiencies there were, which were primarily based on the fact that our property is surrounded on at least 3 sides by wetland. We are being asked to move the building in, well, actually, we haven't been asked by the Conservation Commission to move the building. We've been given an order of conditions, and that has resulted in the request for variance that we've seek this evening. And we have been given site plan review. We have a couple of issues with respect to our utilities to be worked out. We have another issue with respect to availability of water and sewer, and we probably have to realign an easement that we have through the parking lot of what used to be Latitudes and now it's Boston Sports Club. We have the obligation to provide affordable units within this project. 20% of the units must be made to be affordable and there must be the subject of a lottery, and we intend to work with the Community Development Department and its members to create this lottery and work through this process with the Community Development Department. If we had a commercial component, there's a uniqueness to this residential overlay district. If you had a commercial component on the first floor, we would not be here this evening because all of our setbacks would be entirely different.
Do you?
We do not have a commercial component, so that's why we're here. I just wanted to explain what brings us here. And as I've said, the Conservation Commission has vetted the plan and has approved it, and Building Inspector has reviewed my application and signed off that we are asking for the appropriate relief, and I think I've gone over the fact that we need to provide affordable housing. So that's it. I'm happy to answer any questions that the board may have with respect to this application.
So it is no question that 20% of the, are they apartments or condos?
They are. It's uncertain at this time as to whether they will be apartments or condominiums. I believe we're going to be condos.
So are you sure of that tonight, or are you just wondering about it?
No, I just shared it with my client.
So 20% of the condos will be affordable housing.
That's correct.
And has this been approved by the site plan review?
Site plan review has given us a number of issues that we've met with the Peabody Police, and we've talked about restriping the parking lot. That restriping will result in more parking spaces for the sports facility, and will give a more direct access. And we're also looking at entry into a sewer main that runs parallel to our driveway. And
So I don't want to interrupt you, Jack, but so you do not have total approval of site plan review yet?
I do not.
You do not?
Yep.
Okay, so you haven't had, you don't have the complete approval yet of site plan review. You have quite a lot of conditions. I looked at them. Many conditions from conservation.
They have finished with us.
Right, oh yeah, oh yeah, but there are enormous, I mean, there are quite a few. What were there? Do you know exactly the number? Like?
No, I don't know exactly the number.
Like 50? I mean, there are a lot of conditions. And that only brings me to the fact that personally, I would like to wait for site plan review to give their approval, if they do, and blessing. This is, and obviously we can listen to if there are any neighbors in the audience, but this is a very wet area, very wet area. I've lived near here for my entire life, and it's very wet. I think that's great that Conservation gave you a lot of conditions and gave you the approval, but I question the whole existence of this big building. And I would I'm not comfortable going forward with this tonight. I think that if any of the board members have not actually gone and looked at the site, and I know some of you haven't, I really would suggest that you do and take a look into the background of the land before we make a decision. That's just me. Those are my thoughts. And I see if anybody else on the board would like to speak. Colbert, you know you have full debate privileges. You have full range of questioning. '81 conditions from conservation.
Hear everything tonight if we can, and then
Yeah. Anybody in the audience to speak in favor of this? Anybody to speak in opposition? Okay.
Did have Audrey Gordon, who was a direct abutter. She was sitting with me. She had a call that she had to take at 8 o'clock. She has appeared at all of our other hearings in favor, but
Hear it from her, you know.
yeah, I understand.
Oh, that's a good question. Do you have correspondence from other departments on this? You know, we brought up, you know, schools, parking, I'm not parking, but
Public safety.
public safety,
Police and fire.
police and fire.
I saw there was. Dan Sensabaugh through the chair. I did notice that there was conditions from the city council, one of which included a radar on Pine Street. Is that because, is there going to be an entrance? No. From Pine?
No access on Pine. The only involvement with regard to Pine Street is there's an easement through Audrey Gordon's land that will allow us to tie water into a loop. So we'll come down our driveway and then loop out back to Pine Street, but there's no access.
Through the chair. Has the city weighed in on any adverse effects this construction may or may not have on the Lieutenant Ross Park, which I believe
Floods anyways.
it does, and I know that there's the PMLP station, I think, in between, but then after that, there's the baseball fields, and I'd just be curious to hear that.
We received a call from the current president of the Peabody Little League, I think, and my clients went and met with him to see if there was any kind of a impact to be had. We shared copies of the plans, and that meeting in general went pretty well. My discussions involved that the railroad that's behind us kind of separates us. And that's part of the reason, the existence of that railroad bed is a major reason why we've got the wetlands on our property. And you're correct that there is a significant wetland that I think during a prior administration may have been filled.
I'll make a motion to continue this to the next meeting of November 18th. No, I'd leave it open. Yeah.
Second that, and I meant, Stephen, that means the meeting stays open, right? If somebody were to come forward with, next month with, to speak in favor or in opposition, they'd be allowed to do so at that meeting?
Yeah, we'd leave it open for that.
Okay, I'll second that motion then.
All in favor? Any opposed? Okay, Jack, we're going to continue this. Number 6, 251 Andover Street LLC. Mr. Attorney Kelty again.
Notice is hereby given that the Board of Appeals of the City of Peabody will hold a public hearing on Monday, October 21st, 7 p.m., Wiggin Auditorium, City Hall, 24 Lowell Street, Peabody, on the application of 251 Andover Street LLC, care of Attorney John Kelty for a variance from the provision of the zoning ordinance 2019 as amended Section 7.2 and 10 as it applies to the premises known as 251 Andover Street, Peabody, map 29, lot 14. Petitioner seeks a variance and requires relief to the front yard setback where 50 feet are required and 13.5 feet are proposed, rear yard setback where 50 feet are required and 43.8 feet are proposed, left side yard setback where 40 feet are required and 0.5 feet are proposed. Landscaping. The property is located in a BR zoning district. The application and plan are also available to the public and can be viewed at the City Clerk's office and Board of Appeals office, City Hall, in advance and prior to the public hearing.
Thank you, Mr. Clerk. My name is John Kelty. I'm an attorney. I practice law at 40 Lowell Street in Peabody, Massachusetts, and I seek to present a petition of 251 Andover Street LLC. And what has happened is you have already issued a variance for this property, and I'm now moving the building a little bit further to the back of the property. My front yard is actually on the right-hand side of the property because we're on a corner. Gates and Andover Street, we actually have 2 front yard setbacks. So that 5 feet setback is on the left side, and it's a common property line between this and another building that you gave relief for a couple of years ago, and we've built and completed that. Particular aspect of the development. And by moving the proposed building further back, we triggered a rear yard setback. In order to accommodate traffic flow, we moved it slightly to the right towards Gates Road. That triggers our the 18-foot setback. And we are landscaping the front and rear of the property. The rear of the property is going to, it shows on the plan, there's a white opaque fence that will be added in the rear of the property. And we have been through site plan review on this issue, and we have been, there's no conservation filing, and we're actually at the, we have a memorandum that went from Public Services that went from a number of like 13, here it is. It was dated August 1, and there were 8 items on that memorandum, and we're now down to essentially 4 items, and those items are easily remedied. They are requiring, it is a finalized memorandum, they are requiring that I draft an agreement that would allow 251 and cross easements, essentially reciprocal easements, so that one party will be responsible for maintaining the striping, one party will be responsible for the maintenance of our stormwater detention facilities, and they want our existing stormwater management to be in the currently completed building. They want that to, we take the manholes off, determine whether it's clean, file a report with the department. We need a soil evaluator out when we do these stormwater detention, what do you call it? Borings. And we may require a Mass DOT permit for access to the state highway if we cannot install our sewer laterally, which is essentially if we need to open up 114, then we've got to get a Mass DOT permit. So we're happy with these conditions being placed on our renewed approval if the board sees it appropriate. And that memorandum is from Will Pollitt, and it is under date of October 21, 2019.
No questions from the board? Anybody in the audience to speak in favor? In opposition? Hearing none, the matter is before the board.
Motion to close the public hearing. I'll make a motion to approve with the conditions that Attorney Kelty had previously referenced. I think there were 5 or 6 of them. Attorney...
Why don't we just attach memo dated October 21, 2019 from the Department of Public Services? Do you have that? Okay, I'll give it to you.
Yeah. Yeah, because that's not a late communication, it's just that this is identifies what the conditions are. All right, so I'll make a motion to approve with those conditions.
All in favor? Aye. Any opposed? All set. Okay, number 7, Spiro Carabellis.
Notice is hereby given that the Board of Appeals of the City of Peabody will hold a public hearing on Monday, October 21st, 7 p.m., Wiggin Auditorium, City Hall, 24 Lowell Street, Peabody, on the application of Spiros Carabellis for a variance from the provision of the zoning ordinance 2019, as amended Section 7.2 and 7.1.5F, as it applies to the premises known as 4 Antonelli Way, Peabody, map 46, lot 12A. Petitioner seeks a variance and requires relief to the left side yard setback where 20 feet are required and 14 feet are proposed. Accessory structure where 500 square feet are permitted and 840 square feet are proposed. This property is located in an R1 zoning district. The application and plan are available to the public and can be viewed at the City Clerk's office and Board of Appeals office, City Hall, in advance and prior to the public hearing.
Good evening, everybody. Spiros Carabellis, 4 Antonelli Way, Peabody, Mass. I'm looking for relief to build a garage on my property.
Is 840 square feet, where 500 square feet is the allotted.
Yes.
Are you, the existing garage, are you planning on keeping that?
Yes, it's going to stay right where it is, yep.
Okay, and what, that garage as it exists today, does that just, does it have a garage door where it fits vehicles, or is it just for storage?
It has one garage door in an oddly shaped position.
I just have to say that we have had other petitioners come before us for an accessory structure for over 500 square feet, less than 800 and, where is it? Less than 840, and we have not approved it. I think that right now, I don't really see any hardship. I think that it is not a feasible variance to issue this evening. I think you need to perhaps go home and see if you can whittle this down a little bit. It's way too large. My opinion, as chair.
And if I may, through the chair, I do agree. Unfortunately, we have had garages this large come through here before, and they're essentially the same size as a house, which sets a dangerous precedent. But correct me if I'm wrong, but I don't think there's a limit to the number of accessory structures on the property. So if we had one accessory structure at 576, another at substantially the same size, you might be able to accomplish what you're looking to accomplish in other ways. It's just that the way this is structured is just far, far too big.
Okay.
Anybody in the audience to speak in favor?
Hello, everybody. James Marchese, 2 Antonelli Way. I'm next door neighbor. Have no problem with him doing what he's doing. He keeps his property up extremely well. No complaints whatsoever.
It's great. The issue is, and I'm sure he's a great neighbor, but the issue is that the variance he's asking for is above and beyond. So we're going to take a vote.
Okay.
Position?
Hi, I'm Joyce Kirk. I live at 6 Anzio Circle. I live right beneath the property that he is on, and I look up at his backyard. And one of the main reasons that I moved to this area was for the conservation land. He has done nothing to improve the conservation land or to do anything but to move into it. He's up there constantly pushing back, parking a lot of vehicles up there on the top. I've seen him dropping piles of wood up there. And I don't want to look at a huge garage in addition to the stuff that's already up there. Thank you.
Thank you. Anybody else in opposition?
Hi, Edward Nagel, 4 Anzio Circle. I live right next to Joy, and their property is right in my backyard, and it's just too big a structure, you know, too big to look at, really. Yeah.
Anybody else in opposition? Matters before the board.
I'll make a motion to close the public hearing. A motion to approve.
I'll vote.
No.
Nope. That is it, folks. We need to accept the meetings, minute meetings.
You need number 5 back.
Motion to accept the meeting and minutes from last meeting.
Second.
Motion to adjourn. seconded my adjournment.
Okay.
Motion to reopen the meeting. Motion to adjourn.
Second.